Great. So recording is back in progress. Just want to remind everybody this is a conversation for the agents for the Legends of Real Estate. If you have popped into this recording by chance, I'm just going to let you know that we are discussing things openly as a company, and anything that we discuss here is for the agents of the Legends of Real Estate. Jessica, you just jumped in. I don't know if the forms are going to be in the chat for you, so let me throw them back up there so that you can access them. Probably the last time I'll be able to do that. I'm going to go ahead and, Jessica, they should be in there for you now. I'm going to go ahead and share the screen. We're going to pop into the as-is contract for sale and purchase. Part of what we want to do over the next couple of weeks or next few weeks is really just kind of focus on where we are with things. You know, it's been about 4 or 5 months since we've launched these new forms. We're learning things. We're trying to put together some samples so that you can have ideas on, if I say this, what do I need here? If I don't say that here, what do I need there? So we're trying to kind of pull everything together for you so you have some reference points. But these videos, as well as open discussions, are great reference points because you're experiencing different things. This gives us the opportunity to share not only experiences, but what we're learning. We had some great input at the RE Bar conference on Friday. So I did want to share some of those things with you, some things that were pointed out that even in going through them, the documents a few times that may get missed. So that's part of what I wanted to focus on, the contract for sale and purchase today. So I'm going to go ahead and share that as part of my screen here. And hopefully you are seeing, and hopefully be larger in just a minute, the contract for sale and purchase. Let me go ahead and move you guys. And again, I'm going to try and watch the chat. But if I miss something, if you have something that you need, a question you want to make sure gets answered or asked, please just shout out. Let us know that you're there. Okay. And can everyone see the as-is contract for sale and purchase?
Yes. Yes. Yes.
Great. Is it big enough for you to read?
Yes. It is.
Okay, great. All right. So one of the things that I really need to enforce when it comes to any of these documents is everything needs to be in writing. Everything needs to be in writing. Does that mean it has to be on a formal addendum or an amendment? And I can never get it right. Florida Realtors doesn't see a difference between an amendment and addenda. I know those of us who have discussed the meanings of addenda and amendment know that there's a difference or perceive a difference, but for some reason Florida Realtors doesn't. So I think it's an addenda to the contract that they put it when it may actually should be an amendment to the contract. But everything needs to be in writing. Is an email sufficient? In many cases, an email is sufficient. If there is a form, it would really be a good idea. Now, for those of you who we've worked together for some time, you'll know I've never been a big proponent of scratching things out and writing over them. Florida Realtors is very open to that. But please, if your negotiations end up going back and forth more than once or twice, it becomes very difficult to know the last actual agreed upon either amount or term or condition, and it's really important that we're able to see that. So if you go back and forth via email, please keep the emails, put them into app files. Those emails are the support that we need to show how the negotiations occurred. Because inevitably, if you go back and forth or even verbally to negotiate an offer, inevitably, when you finally see the addenda to the contract, or you see, and I'm not a proponent of rewriting, but when you see the addenda or when you see the scratch outs, inevitably something gets missed. And so we really would like to make sure that the emails that go back and forth are there. So we have support when you say, hey, wait a minute, you forgot to change this date, or hey, wait a minute, this cost was supposed to have been moved over. It's really important to be able to have that backing and that background. So I'm opening my mind to the scratch through and initial. But I know dates get left off when we initial because we ran out of space and we think, oh, well, there's not enough space to put the initials and the dates, but we need that date too because that sets the timing for the contract. That sets everything. The last signature and the last initial date really sets the contract timing. And we had a case the other 2 days ago, yesterday, where the question came up: if I detail the pricing, is that change and restart the clock? Well, if the pricing was the same and it doesn't impact anyone, then no, it wouldn't restart the clock. So it's when anything impacts the parties engaged in the transaction. If I add something else, or if I change something else, then yes, it restarts the clock. So whenever anything changes, it reopens the contract for full negotiation and can restart the clock on things. So that's something that we just want to make sure. But please, everything needs to be in writing. Again, if there's an addendum or a way to convey that in writing where all parties sign, that's the best way to make it happen. If you make changes to the document that's been executed, that's okay, but please, as you get into multiple changes, watch out. Thoughts on that? Questions on that? Clarification on that at all? Okay. Parties is not much difference. Something that did come up recently was personal property. The personal property is identified. It was not identified in the NEFAR until later, but the way this reads, the seller shall sell, or Sally sells seashells by the seashore. The seller shall sell, and the buyer shall buy the following described real property and personal property. The advantage to the seller in this is that if there is personal property that's staying, for example, a furnished condo, this makes life a little bit easier. You'll see that when we identify elements that are staying in the property or staying on the property that may be considered personal, how those can be identified. But if there's anything like, the other day we did have an individual who would like to leave their boat with the sale, that has to be done as personal property. And it does need to be done in a bill of sale away from the contract because there are taxes that would be involved potentially. And then there's a transfer of title that would also be necessary on something like that. So that would not fall into the contract itself. But this statement of personal property used to just be improvements. Improvements comes further down, which would be improvements to the property. But this statement here gives us a little more flexibility, or gives the seller a little more flexibility. Notice it does say as is residential contract for sale and purchase. What we're focusing on here is this because 80 to 85% of the contracts that are currently being used are the as is. The difference between the as is and the standard is the standard establishes upfront amounts that a seller is willing to put towards repairs, replacements, or WDO. So it automatically commits them to. Does the as is preclude the buyer and seller from negotiating repairs? No, it does not. The buyer and seller can still negotiate repairs if they choose. However, the buyer, when going into the contract, is aware that the intent is to sell the property as is. So that's the seller's intent, and the seller has no obligation to make any repairs. So that's the major difference in the two. There are some other items related to something like appraisal, which is included in the standard, but the appraisal contingency is not included in the as-is unconventional. There are statements related to the appraisal, and we'll talk a little bit about those. So you've got the property description here, pretty much the same. Did I miss anything from anybody? Okay.
Claire,
And here is something that, yes.
I have a question because here in this contract as is, if the seller doesn't want to fix or make any repairs in the property, even that this contract is like the regular contract when we have the inspection period and the buyer can just end the contract in that period of its inspection, even if this is as is?
So on the standard purchase and sale agreement, standard contract for sale and purchase, upfront written into the contract are amounts that the seller is committing to pay towards repairs. If the buyer and the seller negotiate repairs and they exceed the amount, then it's a renegotiation on the standard. With the as is, up front, the seller is saying, I'm intending on selling this property as is. I do not intend on making any repairs. However, because both contracts have a time period for inspections, if by chance an individual, a buyer, wanted to request repairs, one, on the standard, they are already set up to request repairs. Two, on the as is, they can request it, but they're requesting it with the understanding that the seller has no intention of making any repairs. So a buyer on the as is can submit a request for repairs, and the seller can say, no, I'm selling this as is, so I'm not making any repairs. As long as it's within that 15-day window and the buyer can get out of their own volition, then they can remove themselves from the contract and still get their binder back. Does that answer your question?
Yes, sir. Thank you.
Okay. So yeah, that's really, I appreciate you bringing that up because we are having some confusion on, well, if I'm on the as is, can I even ask for repairs? Sure. A buyer can, as long as it's within that default number of days, 15, unless the number of days is changed by the buyer when making the offer or the seller when negotiating the offer, then of course, during that time period, that's what's known as the inspection period, a buyer on the as is can make a request for repairs. It's just the intention was to sell the property as is. And if the seller doesn't want to make any repairs or even only wants to make one or two of the repairs, the buyer can say, okay, I understand, no problem. I knew that I was going to buy this as is, but I didn't know that there were all these things wrong, or I didn't know this was wrong, and I'm not willing to take it with that wrong if you're not willing to fix it. So I'll just back out. So it makes
Do
it.
they have to fill out a form if they're just going to back out then if the seller says they're not going to fix anything?
You still have to have a release. Yes, you still have to have a cancellation or release. Once you're under contract, anytime the buyer and seller, even if the binder has not been deposited, you need a cancellation to release both parties from the obligation of the contract and to determine what happens with the binder itself. Most of the times in this FAR, it'll indicate that the buyer gets the binder back as long as they've not defaulted. So that does help a little bit with the negotiations.
Okay.
But yes, you would still need a cancellation. Does that answer your question, Dee?
Yes, thank you.
Yasmin, you're okay then?
Yes,
Okay,
sir.
all right.
Yes, thank you.
So the personal property, where we've had some question on is if existing. So together with all existing, and this is where the question of if existing improvements, so that would be improvements to property and fixtures, including built-in appliances, built-in furnishings, and attached wall-to-wall carpeting and flooring, which is known as the real property. So it goes ahead and defines real property here, unless specifically excluded. Other personal property, unless excluded, which remain in, and here's where the other part where the if is causing some concern. In the contract for sale and purchase, in the purchase and sale agreement that NEFAR had created, it said if existing. The way this reads, or by other terms of this contract, the following items which are owned by seller and existing on the property as of the date of the initial offer are included. So the concern is because there's a list here of items, it's intimating that they are owned by the seller and existing on the property. It doesn't say if owned by seller and existing on the property. So the question becomes, do you have to cross out any of these? At this point, we're saying, no, you don't have to cross these out because it says which are owned. And if they're not owned by the seller, which would be something that's leased, then it would have to be something that's negotiated. So watch that because that word if has been dropped from here. So there could be the case where, and a couple of our agents are saying, well, I'm going to go ahead and line through items that the seller does not own or does not, that do not exist on the property. That's fine. You can also use the personal property disclosure, which is more defined as to checking the boxes of what stays and what doesn't stay. It also does ask the question about video and audio recording, which may be occurring on the property, which is a disclosure item. So that can be an additional element to help you when you're taking the listing. And when your seller is negotiating, if they're concerned about a misunderstanding of any of these items, feel free to line out an item that does not exist on the property so it's clear. Or you can exclude them down here. Notice we do say personal property is included in the purchase price, has no contributory value. This is so it doesn't impact the appraisal. It's also clear that anything staying, so any furnishings, for example, personal property staying, would have no contributory value. So a little different here when it comes to personal property than what we may have been used to with the NEFAR. A little more defined, also a little less defined on if, the word if being in here, if owned by the seller and existing. Questions on that, clarification on that? We'll make sure that everybody's okay with where we are with furnishings. The purchase price section is flip-flopped so that we start with the purchase price at the top. I will tell you, this should always add up when you're using numbers. This should always add up except in two cases. Those two cases would be if it's 100% VA financing or 100% USDA financing. In that case, these numbers would not add up. So for example, if it was 500,000 is the purchase price and it's a 100% VA, then the loan amount would be 500. The balance due at closing would be 0. And the binder of $2,000 would still appear here, so the numbers would not add up. On the binder, the first option is accompanies the offer. We do not have an escrow account, so in most cases, we would not have the binder accompanying the offer. However, if the buyer chooses to accompany the offer with the binder, it would need to be deposited to the title company immediately. The most used option is this second one where it says is to be made within a certain number of days, 3 days if left blank from the effective date. Notice it does fill this in automatically if you don't choose or the buyer does not direct you as to how they would like the binder deposited. If neither box is checked, then option 2 shall be deemed selected. So please just watch.
Sorry.
Go ahead.
Most of the time we use 3 days after we accept the seller accepted the offer, right? Most of the time. So we have
3 days
is to be made within 3 days.
Correct. So you would use this box right here and fill this in with 3 days. I know that there's a default here. If you can, please try to remember to fill in the blanks so that it's clear for everyone. Not, we've got the title company, you've got all these aliens reading these documents. So we want to make sure that everything is clear to them. So leaving blanks, while I get the blanks can be filled in automatically, filling in the blanks makes sure that you have clarification as to what the intention of the buyer is or what the seller's intention is in countering an offer. But you are correct, this is a very common space to use. In other words, the binder will be given a certain number of days after acceptance by all parties.
And just to
Please remember that.
Yeah, I'm sorry. Effective date is when both parties already signed the offer, right? The contract.
Right.
Well, no,
Yeah, and
I mean, the last signature that we see, that is when we start counting the dates, right?
well, let's even come down to paragraph 3 and then we'll bounce back because it defines effective date right here. If not signed by the buyer and seller and an executed copy delivered to all parties on or before a certain date, this offer shall be deemed withdrawn. So the effective date is not only when the last person signed, but then it's delivered to all parties. So the prima facie evidence, the visual evidence of execution would be the date that all parties sign. However, to know that you have a bona fide contract, all parties have to be notified. So an executed copy is supposed to be delivered back. Does that make sense, Yasmin?
Yes.
Yeah, so you're saying, yes, the effective date is the last date everybody signs, but remember, it's also supposed to be communicated, because if I don't know that you've signed and now you've signed it and you believe it's executed, but it hasn't been conveyed back to me, I have no idea that we're under contract. So we have to let the other party know. So you also want to know when it was communicated back to the other party. That could change an effective date if the other party can prove that communication was not made. Karen was asking, what is the actual time of day cutoff for response? It's the end of day, and that's 11:59 p.m. and 59 seconds. There is no longer a 7 or a 5 unless you have written it in. If you write in here, for example, if I wrote in 1:21 by 5 p.m., then that would be the date, or the time, excuse me. But right now it's 11:59 and 59 seconds. So just bumping back up here to the purchase price for a second. Just as a reminder, escrow agent is the agent that holds the binder. Does it have to be the same agent that's closing it? No, it doesn't. A buyer can choose to have their binder held wherever they're the most comfortable and wherever they would like, as long as it is a guaranteed location. So a savings and loan, a bank, an attorney, any of those locations will work. It's wherever the buyer wants to have their monies held.
So that means that changed too, because before I remember that the seller put everything that they wants, like the closing company where you have to put the binder and everything. So now the buyer is who is going to choose where to put the binder.
Actually, it's always been this way.
Oh.
The closing instructions that were provided by the listing agent were an indication of what they would like or what the seller is requesting. The buyer had no obligation to deposit the monies in those locations. So if I'm the listing agent and I tell you that we're closing at J. Riley, and the buyer says, well, that's great that you're closing at J. Riley, but I'm going to put my money over at Landmark, they have every right to do that. They've always had every right to do that. As long as there's proof of funds and as long as the funds are held in a guaranteed location, there's no problem. The advantage of holding a binder where the closing takes place is then the buyer's agent does not have the obligation to ensure that the monies are transferred at least 3 to 5 days prior to the closing so that the monies can clear and be available for closing. So it removes a step, but it has always been the option of the buyer to place their funds wherever they would like. The seller, via the listing agent, is telling you what their intentions are and what they would like to see, but there was never any obligation of the buyer to place those funds in a requested location if they did not want to.
Thank you.
Yeah, so I see where you're seeing it seems like it's a little different because we started adding closing information or closing instructions. Those are closing instructions. This is where we're closing. If you don't want to put your money here, the buyer has no obligation to do that. Under the financing section, this is new. And just to kind of clarify, financing expressed as a dollar amount or percentage. Dollar amount or percentage. So, excuse me, where the percentage can come into play is if it is a 100% VA or USDA, you can put 100% in here. And then as the seller's representative or working with the seller, if they change any of these other numbers, you don't have to change the loan amount. Same thing can be said about conventional. If I'm getting an 80% loan and I've made an offer at 600, but the seller wants 625, they only have to change the 625 and the amount to bring to closing, potentially the binder if they want to negotiate that, but they don't have to change the loan amount. So the amount that the buyer is getting for their loan can be expressed either as a dollar amount or a percentage. So think about that. Sometimes it's a little easier to express it as a percentage, especially if it's 100%. And from visually and sometimes in the mind, if you're presenting 100% there and the numbers don't add up, sometimes it makes people feel a little bit better. It's like, oh, okay, well, I see why it doesn't add up now. There's the binder, there's the amount they're paying, they're getting 100% financing, they don't have to bring anything to closing. So visually, think about what works well, think about what you're trying to communicate, think about where you are in the negotiation. But you do have the option to express the loan amount as a percentage. This is the balance due at closing. There should always be a balance due at closing, even if it is zero. Please don't forget to fill that in. Since it's flipped, for those of us who have been using the NIFAR purchase and sale agreement to now have a contract for sale and purchase, flipped, it's a little different. So make sure you fill in all that's appropriate. If there is financing, there should be some sort of amount here. Otherwise, you're conveying that the property is being purchased as cash. Time of acceptance, the offer and counteroffer. So we just talked about this. This defines your effective date. Although, unless otherwise stated, the time for acceptance of any counteroffer shall be within 2 days after the day the counteroffer is delivered. So the previous documents through NIFAR had it as a default of 24 hours. So if you're expecting something different, you would have to either change this or put a comment into paragraph 20. But this gives the seller or the buyer 2 days after a counteroffer is delivered to make a decision. It's kind of a long period of time. Oftentimes it doesn't occur. People are responding fairly quickly, but just so we know, it is 2 days. So if you don't get a response in 2 hours, that doesn't mean that you're not getting one. That just means they're taking their time to make the response. They have 2 days. We good there?
And you don't need to put a time on that. You don't need to say like by 5 o'clock.
What if the
anything. They
date
have until
passes here?
midnight.
Yes. Up here?
Right.
So for the date, so an executed copy delivered to all parties on or before a certain date, you can add a time here if you'd like. So again, the timeline is 11:59 and 59 seconds. So if you don't put a time in here like 9 p.m. and I respond to your offer and counter offer at 11:58, that's the date we went under contract. The next day is day 1. So can you put a time in there? Sure, I could say respond by 1:25 at 7 p.m.
Clark,
If this date passes, so if it's, if we pass 1:22, excuse me?
I had a quick question regarding this.
All right,
This
one
statement
second,
is-
Jessica.
Oh, sorry.
One second, Jessica. Dee, are you clear before we move on?
I am clear. I like just putting a time on there so that I know that they have until 7 PM. I just think that that's makes it clear for everybody that we're waiting until 7 PM to know what happens. Okay.
Yeah. Otherwise, you're waiting till 11:59,
Right, okay.
which which can happen. Okay, sorry, Jessica, go ahead.
I just wanted to clarify that acceptance of any counter offer shall be within 2 days. Does that mean to receive a counter offer? To actually receive the counter
So
offer, where when you receive a counter offer, there's another date on that particular form as well.
it depends what you're using for the counteroffer form. So what this is saying is that any counteroffer, so if I make an offer to you,
Mm-hmm.
right now I'm waiting for your acceptance. You have a date and a time based on what we've put in here as to when my counteroffer is good for. And that, or excuse me, when my offer is good for. Now you send me a counteroffer and I receive that today, and today is the 21st. So if I receive it today on the 21st and you don't say anything different, you send it in an email format, or you don't send it on a form that has an additional date. For example, the NEFAR one had a 24-hour window. The counteroffer form right now, I'd have to look it up. I don't know that it has a time frame that's anything different.
I
The
just,
FARBAR one.
right, the Florida Realtor counter offer has a space where you can actually put in a time and day, and then it states 24 hours after whatever day or time you put into the form on that line item.
Okay, so if the counteroffer form from that we're using now, if you put in 24 hours, then it supersedes this because anything that's written supersedes what's printed.
Perfect.
So if you were to send me an email that says we counter at 550 on your, $525,000 offer, then I have 2 days to respond to that, unless you say differently in your email.
Okay, thank you.
If you present it on the counteroffer form and you put in 24 hours, then I have 24 hours because that supersedes what's here. Karen was saying that so often agents count the date of acceptance as day one. Part of the confusion is you're going in or out on audio. Okay. I thought it was maybe the connection over there. So thanks for clarifying that. Karen is correct. So if we get acceptance today, even at 11:58, tomorrow is day one. Is anybody else having trouble hearing me?
No, I hear you good.
Okay.
Sound good.
I'm sorry.
I can hear you fine
Was
on
that
my
you,
end.
Rhonda?
Yep, I can hear you fine.
I can
Sorry,
hear
Rhonda,
you.
you bounced in and out. I don't know if it was you or me, Rhonda. You bounced in and out. Okay. I'm going to move forward then. So the effective date of the contract shall be the date when the last one of the buyer and the seller has signed or initialed and delivered this offer or final counteroffer, which is the effective date. This includes all addenda. Please remember that all addenda have to be executed, and there are certain addenda that are going to be required. And if those addenda aren't initialed or dated, it changes the time of acceptance. For example, if I'm selling a property or I've listed a property that it's located in an HOA, the HOA addendum is required. If we negotiate based on this document, this contract for sale and purchase, and we get all of this executed, but we don't execute the HOA addendum, then the HOA addendum, when that's finally executed, is what sets the effective date. So all addendum must be included when you're negotiating. I know our packages, our purchase and sale packages are much larger now, but you do have to have all addenda, especially any required addenda, lead-based paint disclosure, HOA disclosure, CDD disclosure, condo riders, condo FAQs. All of these things apply. Seller's disclosure, seller's property disclosure does not apply. Any questions on the addenda that need to be there? There have been a couple of lag times. Okay. Wait a minute, what you said. All right. So I'll try to make sure that we're not lagging. This also and we'll bring it up again later. This includes FF and GG. That's why I want to go over FF and GG, because there's been some confusion about how to use those and when we use those. But if you've identified anything in paragraph 19, any addenda in paragraph 19, then that item has to be included to have a fully executed contract. It did state this in the NEFAR contract, but it doesn't state that here. So please remember, the effective date is going to include the dates that are on the addenda. Closing date you can add on or before. There's been some concern about, if I put in a date here, shall occur on February 3rd. Do we have to close on that date? Can we close before that date? If you just write on February 3rd and all parties want to close earlier, as long as there's agreement to close earlier, you can close earlier. If you want to write on or before February 3rd, you can do that also. There still has to be agreement by all parties. So this was clarified by one of the attorneys at the RE Bar conference. Even though it says date, as long as a specific date, all parties, as long as they agree to close earlier, you can close earlier. It doesn't have to be on that specific date.
Clark, I have a question.
Yes?
All the addendums has to be signed to, or just sent to the other party, the addendums?
To have full execution, you have to have all addenda signed and dated. I know that something like an HOA disclosure only has initials, and that's because it's supposed to be a part of the contract. But something like a lead-based paint disclosure where there are signatures and dates, they all have to be there. So that could impact the effective date.
Okay, thank you.
Clark, can I ask a question real quick on that? So
Sure.
if we put GG where we put contingent on coming to agreements for the buyer's brokerage commission, if that gets finalized 3 days later, that doesn't include that. I mean, so the contract is still on the original date and not the new, like the signed agreement for the compensation.
Okay, so the GG creates a contingency for the execution of a compensation agreement. As long as GG is executed by all parties as part of the contract, then it does not, the date of the compensation agreement does not impact the effective date of the contract, because the compensation agreement is not between the buyer and the seller. Compensation agreement is either between the seller's broker and the buyer's broker, or between the seller and the buyer's broker. So that agreement can have a completely different date from the effective date of the contract itself. However, remember, GG does create a contingency on the contract that a compensation agreement will be executed. So that contingency then would have to be met as part of the contract terms and conditions. It does have an end date. In other words, there's a default number of days of 3 days to create or to effectively execute a compensation agreement. So that would then mean that if we don't do it within 3 days, the buyer can back out, which is what it states in GG. Or if it is executed within the 3-day window, then that removes the contingency.
Okay, thank you.
And the effective date of the contract remains the same.
I have one more follow-up question that I got from what you just said. I received a purchase and sale agreement which had the compensation agreement added into section 19. Should we had not accepted that and had it taken off?
The compensation agreement should never be in the contract, because the compensation agreement is not a document that's between the buyer and the seller. However, we're going to have to just give grace as much as we can. We don't want to slow the process down.
Okay.
I love that you noticed that, and I love that you were willing to make a change to that. That shouldn't be what holds full execution up or acceptance. It's just giving grace and helping people to understand that maybe that shouldn't be there is kind of
Okay.
where we probably need to be.
Okay, no problem. Thanks.
But you bring up a great point because it shouldn't be there. We should take it out. But what are we talking about? We're talking about a compensation agreement. That's the last thing we need to have is for a buyer or seller to say, well, they wouldn't move forward because we didn't have a compensation agreement. And then it appears that we're slowing the process down because we're identifying how we want to get paid. The whole part of the settlement was the buyer and the seller, the buyer negotiates with the buyer's agent, the seller negotiates with the seller's agent. So there should be no discussion of compensation or concessions within the buyer and seller unless it's things that the buyer and the seller are agreeing to. It shouldn't have anything to do with the brokerages. It should all be within whatever the buyer and seller are agreeing to. So yeah, we don't want the perception to be that we delayed a negotiation because of compensation to a brokerage.
Okay, thank you.
So that's why we don't put it in there. Or that's why we don't put the compensation agreement in there. There'll be other language that's in there. Okay. Are we okay on dates for execution?
Yes.
Okay. Extension of closing dates. These are automatic extension, occupancy, and possession. Really nothing major difference in there. Check if the property is leased. Please make sure that we're aware if it's leased. When you're listing the property, we do need a copy of those lease agreements for the file. We should be aware of those. Maybe put a spreadsheet together for the potential buyer that shows lease payment, or excuse me, rental amounts, lease amounts, and lease end dates. That should really help. Remember, we do have to provide copies within 5 days of the effective date to any potential buyer. So that's something to make sure that we're aware of. And then we do have to provide it at the originals at closing. Assignability, this is slightly different from the NEFAR. The NEFAR purchase and sale indicated that if no box was checked, then the buyer may assign it but not be released from liability. The default here, if one of these boxes is not checked, so please try to check the boxes and don't depend on the defaults, because sometimes there's a confusion as to what the default said versus what the original intent was or what the actual intent is. So first, that the buyer may assign this and thereby be released. Second, the buyer may assign this but not be released from liability. Or third, may not assign this. So if no box is checked, then the buyer may not assign the contract. I prefer that, but please make sure that your seller and you are aware of what the buyer is intending. We're getting a lot of subject to offers. We're getting a lot of investor offers that are marketing the property. We had a seller contact the listing agent last week or the week before saying, why is my property being offered at a higher price out on this website? They were under contract. It was an investor who then went ahead and used equitable title to go ahead and start marketing the property at another amount. They were not happy with us because they felt that we hadn't done a good job of getting the price for the property, despite the fact that they had agreed to the contract. So anyway,
In that
just watch
case,
that.
is the best thing to do then to check the box that they may not assign the contract?
May not assign the contract. That would prevent them from marketing the property or using equitable title to market the property, because they would no longer be able to assign it to someone. They would have to close and then go ahead and sell the property.
Okay, so that if that box was checked, that would have alleviated the problem that you just mentioned, correct?
Yes, but in
Okay.
most cases, what I will say is that investors are using either the first or the second. That's oftentimes an indication you have an investor, especially if they're may invest, despite the fact that you may already know their investor based on who the buyer is, being an LLC or corporation or trust. But those can also be individual buyers too. So
Clark, can I add to that?
financing,
If I get an
yeah,
offer,
go for it.
If I get an offer on a listing that has these checked, I do disclose that to my sellers and I tell them that don't be surprised if they try to put it on an open market and sell it before closing. So I think that that's something that we need to communicate to our sellers when you see that checked.
Yeah, absolutely. Because they can counter with the other. And that'll tell you a little bit more about what the intent of the potential buyer is. All right, financing, cash. No financing contingency or the contract is contingent. Please make sure that you're watching your timelines. 30 days should be sufficient based on the way that the document is written. But if you're changing any dates, make sure that you know when they have to make application, when you're planning on having your inspections done, what the inspection period is. So 30 days if left blank. This is the loan approval period. The buyer would be obtaining approval for. Please make sure you're aware of the type of loan. If it's an other, is it an assumable? Is it seller financed? Excuse me. And then check one, you can check one fixed or adjustable. And this relates back to the loan amount in paragraph 2C. So that was where we would say the loan amount or 100% or 80%. Excuse me. The buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to the lender. So they've got to get loan approval, their financing, and the buyer's mortgage broker or lender having received an appraisal or alternative valuation of the property satisfactory to the lender. This is not making it contingent on the appraisal. This is just saying that the lender needs something to show the value of the property. Even if a lender were to receive an appraisal or some other valuation of the property that might be less than what the buyer is paying, if the buyer is still able to afford it, this would not be the appraisal contingency. This would not be an appraisal contingency where the buyer could get out. So please make sure that you're watching that if it is conventional and you are concerned about what the buyer has offered versus where you believe the appraisal for financing will come in, you'll need to include the appraisal contingency addendum. The FHA and VA addendum already have the appraisal contingency written into them. So if it's FHA or VA, you must have the FHA or VA addendum. So there you will be covered with the appraisal, but a conventional is not covered. Even down here where it says the loan approval, which requires the buyer to sell other real property, shall not be considered loan approval unless rider V is attached. So if they have to sell something, you have to include the rider that discloses that. So this is, again, I know the packages are getting larger, but this tells us right here, look, if you don't attach the addendum, this doesn't give them the outs if they have a property to sell.
Clark?
Yes.
Okay, I'm sorry to ask you just to clarify, but on line 94, the fact that it says the buyer's mortgage having received an appraisal satisfactory is not the contingency. That is just why? Why do they even say it then?
They're not because, well, they're looking for some valuation, the lender because the lender is going to require some element of valuation to determine the value of the property and their lending capability. But that doesn't mean that even if the property came in valued less than what the buyer is willing to pay,
That's a
that the
contingency.
lender is not
Yeah.
correct, or that the lender is not still willing to lend. The lenders, remember, the appraisal sets the amount that the lender is willing to lend. They're going to lend to the lesser of the two amounts, the appraised value or the purchase price. Just because the appraised value is less than the purchase price doesn't mean the buyer can't still afford it. This doesn't say if it doesn't appraise, we can get out. That's an appraisal contingency.
Okay, thank you.
And so you just to finish that sentence, or alternative valuation. So if I'm conventional and the lender accepts a CMA as the value to lend on, that's not an appraisal contingency.
Thank you.
So yeah, that's really good point. Thanks for clarifying that, because it is something that we're not as used to. And so when it's conventional, if it's conventional and your buyer is concerned, you'll need to make sure there's an appraisal contingency. And then your seller, when you receive this offer and there's an appraisal contingency, you as a listing associate, you're going to have a hard and fast talk with your seller as to what you believe the appraisal will come in at, and whether the buyer can actually afford if the appraisal doesn't come in where the purchase price is. This does go into a little bit further detail about diligent effort, includes but not limited to timely furnishing of all documents, similar to what was in NEFAR, but a little more detailed. This is the other part when we're working either with the buyer or seller, but mostly with the seller. The buyer shall, upon written request, can be an email, keep seller and broker fully informed about the status of the buyer's mortgage loan application, loan processing, appraisal, and loan approval, including any property-related conditions of the loan approval. So this reminds us, when we're the listing agents, that we need to make sure that in writing we're communicating with the buyer's associate, buyer's agent, and saying, hey, where are we with X? Where are we with Y? You'll see that we can go ahead and make those phone calls. Buyer's mortgage broker, the communication in writing. Remember, everything has to be in writing. I know we like to go back and forth sometimes verbally. Oh, well, what do you think about 550? Oh, what do you think about 560? Oh, what about 480? You know, so those things need to be in writing, just like requests. Once we're under contract, as the listing associate, you have a responsibility to the seller to ensure that the buyer is doing what they're doing. Why? Otherwise, they're in default. So the buyer shall, upon written request, keep the seller. So right at the onset, make a note. I need to send, one of the first things I need to do is send the listing agent an email that says, we expect that the buyer will keep, you and the buyer will keep us informed of all timelines, responsibilities, requests, issues, concerns, any of those kinds of things. Make sure that you get that in writing at the onset of going under contract on behalf of, or in working with the seller, and in ensuring that you have a transaction that you're working for the transaction itself as a transaction broker. So this next section, it's really got to kind of, let's go through it. It's just, if within the loan approval period, the buyer obtains loan approval, the buyer shall notify the seller of the same in writing prior to the expiration of the loan approval period. Or if the buyer is unable to obtain loan approval within the loan approval period, but the buyer is satisfied with the buyer's ability to obtain loan approval and proceed to closing, the buyer shall deliver written notice to the seller confirming the same prior to the expiration of the loan approval period. So this puts the buyer on notice, and we have to think about this when we're working with buyers. The buyer has an obligation in writing to let the seller know prior to the end of the loan approval period that they are removing their loan approval contingency. They have an obligation. So you have an obligation when working with the buyer to ensure that the seller knows that you have loan approval. That the buyer has loan approval, excuse me, not you. Well, you working with the buyer. That the buyer has loan approval. And if the buyer isn't able to get loan approval prior to the end of the loan approval period, they've either got to remove themselves from the contract or let the seller know that they are going to go ahead and move forward unless the seller and the buyer agree to extend the loan approval period. So this is different. The buyer has got to know. So you working with the seller, you've got to have that tickler there going, okay, we're getting close to the end of the loan approval period. I haven't heard anything. Time to reach out again. Time to call the lender, because remember, you've got that approval. You asked for it in writing at first. You now were given the permission to talk to the lender and everybody else. Now you're making those phone calls and you're getting a little bit of concern. Time to be reaching out or sending emails to ensure that things are in writing. Do we know what's missing? Are there issues with the loan approval? We're coming up on the end of the loan approval period. So there's an obligation from the buyer right here to make sure that the seller is aware. Now, before we move on, are we okay with that?
Yes.
Okay, let's just say, and when we get through the rest of this, we'll see. If buyer is unable to obtain loan approval within the loan approval period or cannot timely meet the terms of the loan approval, all after the exercise of good faith and diligent effort, the buyer may terminate this contract by delivering written notice of termination to the seller prior to the expiration of the loan approval period, whereupon, provided buyer is not in default under the terms of this contract, the buyer shall be refunded the deposit, thereby releasing the buyer and the seller from all further obligations under this contract. So I'm a buyer, I have to get loan approval. I have an obligation to let the seller know prior to the end of that period, that loan approval period, whether or not I have loan approval, whether I can get loan approval, or if I need to extend the loan approval period. If I know that I can't get loan approval in writing, not a loan denial letter, but in writing, doesn't say anything about it. I don't have to provide a loan denial letter. If I can't get loan approval, all I have to do is send, or the agent has to send a letter to the other side, to the seller, saying they're unable to get loan approval. So a cancellation or saying that they're unable to get loan approval based on the loan approval period. But as long as they've exercised good faith, they get their binder back. So a letter of loan denial is not required, just something in writing indicating that they have not been able to achieve loan approval. And then here's the third part of that. If the buyer fails to timely deliver any written notice provided for in paragraphs 8B, 3 or 4, 3 up here, or 4 here, so either of these, 3 or 4, to seller prior to the expiration of the loan approval period, the buyer shall proceed forward with this contract as though paragraph 8A above, contingency, loan approval contingency, financing contingency, has been checked, excuse me, 8A, paragraph 8A cash. Let's make sure, 8A cash, so it changes it to a cash transaction, has been checked as of the effective date, provided, however, the seller may elect to terminate this contract by delivering written notice of termination to the buyer within 3 days after the expiration of the loan approval period, and provided buyer is not in default under the terms of this contract, buyer shall be refunded. So here's the deal. I'm working with the buyer. The buyer gets loan approval, but we don't in writing notify the seller. The loan approval period ends. The seller now says, I have a backup. I'm terminating your contract, buyer, because you didn't notify me that you got loan approval. Or I'm terminating because the seller can now terminate because you didn't tell me that you were unable to get loan approval. So if the buyer in writing, when you're working with the buyer, if the buyer in writing does not notify the seller that they either got loan approval, removing the loan approval contingency, or moving ahead despite the fact that they haven't got loan approval, or have written that they can't get loan approval, within 3 days of the end of that date, the seller can go ahead and terminate the contract. So if they have a backup offer that's going to get them $5,000, $10,000, $20,000 more, they can terminate that buyer agreement. We're not used to having to notify the seller about loan approval prior to the end of the loan approval period, other than potentially extending the loan approval period if we have a challenge. But this section here obligates the buyer to notify the seller. So if I'm working with the seller and I'm doing my due diligence and I'm checking up and I say, well, we don't have, and I called the mortgage person and they haven't called me back, and the loan approval period ends, And now the seller says, well, I've got this other offer. Let's go ahead and terminate that. And the seller initiates a cancellation and termination. The buyer says, well, wait a minute. I've got loan approval. I'm sorry. So sad. Too bad you didn't notify me before the end of the loan approval period. So I had no way of knowing. So everything needs to be in writing. Even though many of you are on mute, I can see your eyes roll, or I can hear your eyes rolling and heavy sighs. Anybody want to add something there?
I would like to add a question. So what's to prevent a buyer who all of a sudden changed their mind? They're going through the process and then they say, I can't get loan approval. Write a letter and tell them I can't get loan approval. I want out of the contract.
They could do that. That's paragraph, that's section 4. I can't get loan approval and I notify you in writing before the end of the loan approval period.
Do I need to have a letter that says they didn't get loan approval, or what if they just say that they can't get loan approval? I mean, what proof do I have if they tell me to write a letter and says they can't get loan approval?
You don't have any proof. The only thing you can do is contact the lender, because obviously you've been given that right, is to contact the lender and confirm that their loan was denied.
Okay.
Or you can, I'm sorry, what I'm saying, you were talking about the seller themselves. The seller themselves can, through you, request a letter of loan denial. But the only obligation, according to the contract, to the contract, is that they have to notify you in writing that they can't get loan approval. There's nothing in here that states that they must provide a letter of loan denial. That would have to be a request from the seller to the buyer.
Okay, so if I'm the listing agent and I'm representing the seller, I want to really make sure that this deal is going to happen. So should I still continue to show the property and take backup offers in case within that time period they say that they couldn't get loan approval, or they send me a letter?
Well, we're listening as a transaction broker, so we're kind of trying to work for the benefit of all parties in the transaction. So if you're under contract and you've moved it from active to active contingent, that allows you to continue to show the property and
Okay.
potentially receive backup. If you move it into pending, that ends your showings. So it would be a discussion you'd have to have with the seller to say, okay, we have an offer, we've gone under contract. We have to discuss our feelings about what's been provided, how comfortable we are, how confident we are. We're very confident. Okay, therefore, we're going to go ahead and move to pending. We're going to stop all showings, which means we probably won't have any opportunities for backup. Are you okay with that? Yes, I'm okay with that. I don't want anybody else in the house. Okay, great, fine. We go for active to pending.
Okay.
Well, I still feel good about it, but I don't want to miss out on any opportunities. Let's just move to active contingent. Okay, that's fine too. Somebody else was going to say something about this section, maybe? Val was asking, whenever I placed a property into active, oops, let me go back 1 second, Val. Whenever I place the property into active contingents, all showing requests cease. That's going to be a responsibility of other agents. I know that when the market was going crazy, even active contingent did not stop individuals from putting in backup offers. I think you're right. Now we're in a much clarified is, if you move a property to active contingent, the rules of active contingent are that your property will still accept showings. If you move it to pending, then based on this, essentially change their mind about the property for another 15 days after the inspection period. So if I'm understanding you correctly, Kay, what you're saying is it's not fair to the seller because it's like giving the buyer an additional 15 days to back out, unless, of course, the you no. You're no. Yeah. 15 days. Again, can you all hear me now?
I can hear you now. I couldn't hear anything that you were saying before. It was just totally cutting out.
Okay. So, all right. I should be back. All right. So what we were saying is, what Kay was saying is, this seems unfair to the seller because it could potentially give the buyer an extra 15 days if they had a 30-day loan approval period to just send a letter that says they weren't able to get loan approval. And she's correct. However, it would be the seller's opportunity to say, then we need a letter of loan denial, or as the listing agent to contact the lender to find out what the problem is with the loan in order to determine whether or not the buyer is actually providing true facts. But it can also be an advantage to the seller, correct? Because if the buyer doesn't provide in writing that they went ahead and are removing their loan approval contingency, the seller, after the loan approval contingency, can back out, even though the buyer may have had loan approval for a different offer. So it could work either way. If they had a backup offer. A lot of the things that we talked about at Ari Bar Camp with the economics and the real estate market, many people are saying that we're going to end up towards the mid-year back in a multiple offer market. So I'm guessing that these three sections, section 3, 4, and 5, are going to be heavily impacted by how the market is, what the market looks like. Anything anybody else wants to add about these three? If it's marked. So everybody seems to agree that if it's active contingent, it's hard to get backup. I don't disagree. In this market, you're probably 100% accurate, because in this market, active contingent is telling a buyer that someone else has already got it under contract, so I need to move on to something else that I know I can get. It's not as competitive as the market was 2.5 years ago. I don't like the fact that that a denial letter is required if a loan denied and have to ask for it. Yeah, Kay is saying that it doesn't seem right that a loan denial letter is not required. It's just in writing. So if someone requests a loan denial letter, then that's something you have to get. Although I'm figuring, and what's been done before would probably still apply here, that a buyer can request a loan denial letter from a lender, and many of the lenders will provide it. So, but this is just something to be aware of, because a seller can cancel a contract. We're not used to that. We're not used to have to removing the loan approval contingency or notifying the other party if we can't get loan approval. And then the seller can actually come in and cancel the contract based on the loan approval period. So it's slightly different. Before I move on, anybody want to add anything else? Closing costs, just a couple of comments. Municipal lien used to be on both parties, used to be listed either on the buyer side or the seller side, it's now a seller cost. Survey is now a buyer cost. Title evidence, 15 days if left blank. It used to be 10. And it's 15 days on a finance property and 5 days on a cash property prior to closing. So it breaks it out a little differently. It does require that if a seller has an owner's policy of title insurance or other evidence of the title covering the real property, the seller shall furnish a copy to the buyer and the closing agent within 5 days. So buyer and closing agent within 5 days of the effective date. So if you have a past policy that you want to use when you're working with the seller, it's not an obligation to provide it to both the buyer and the closing agent. The buyer shall designate the closing agent and pay for the owner's policy and charges and premiums of any lender's title policy and endorsements. So here in this section, when we're talking about who's going to pay, the seller or the buyer, we're getting a lot of buyers, or excuse me, a lot of offers from investors that are offering to pay buyer closing costs or buyer's title insurance or owner's policy. I shouldn't say just from investors. There's another brokerage that owns a title company that is attempting to push all of their transactions through that title company. And so moving these costs to the buyer in an attempt to do that, please make sure that you have a frank conversation with your sellers about, while this is a cost and it could potentially be a saving, does it make sense? These are I guess they're just conversations you're going to have. If it makes sense to have the seller pay what the seller customarily pays and the buyer pay what the buyer customarily pays, or is the offer enhanced enough that the buyer paying for these items releases the seller from making those decisions, if it makes the most sense for them. Under survey, if the seller has a survey covering the real property, a copy shall be furnished to the buyer and the closing agent within 5 days after the effective date. So now it calls for that survey, if they've got it, to be furnished to both the buyer and the closing agent. A lot of people are missing the home warranty section. There is no default fill-in for the home warranty section. So please make sure you make a selection. Either the buyer is going to pay for one, the seller is going to pay for one, or it's not applicable, they're not asking for one. But there is no default, and that seems to be getting missed quite a bit. Special assessments. So at closing, the seller shall pay the full amount, and these special assessments are public body special assessments. I mean, special assessments that come from a homeowners association or a condo would be disclosed in those different addenda. These are for special assessments, often known as public body special assessments. And you would need to check one, although if neither box is checked, then option A shall be deemed selected, that the seller shall pay the installments due prior to closing and the buyer shall pay after. If there's any difference in that, please make sure you select B. Otherwise, A is automatically selected unless you select A. Permits. This was not an element of well, it was an element of the NEFAR contract, but wasn't as clear. So there's a permit disclosure section. There's a disclosure related to permits, and then there's an element of closing out permits in the standard items. So the permit disclosure, except as may have been disclosed by the seller to the buyer in a written disclosure, again, written disclosure, the seller does not know of any improvements made to the property which were made without required permits or made pursuant to permits which have not been properly closed or otherwise disposed of pursuant to the section. If seller identifies permits which may have not been closed or improvements which were not permitted, then the seller shall promptly deliver to the buyer all plans, written documentation, and other information in seller's possession. So this just reminds everybody that permits are extremely important. They should be closed out. You can do a permit check. Oftentimes many of your home inspectors are doing permit checks. It's just if you notice that anything's been done to the property, you may want to have it checked out if permits were pulled and if they're closed. This is another one that gets missed quite a bit. Energy brochure. This has been in both the NEFAR and is in the FAR-BAR. Buyer acknowledged receipt of the Florida Energy Efficiency Rating Information Brochure. This is why I keep asking for it and ask many of you to please go ahead and send it through app files and then submit the brochure to the checklist. There is a requirement for us to provide the buyer with the energy efficiency brochure. And if the house was built before 1978, we do have to provide them not only with the disclosure, but with the brochure also. So that's why I ask you to please submit it to the checklist after you've sent it to them. Neither the energy efficiency brochure or the lead-based paint brochure have initials or signatures on them. Can you add them? Absolutely. If you would like. Otherwise, please just go ahead and submit those brochures to the checklist so that we know that you've sent them off. And by submitting them to the checklist, you are saying that you've provided them either in person or that you've sent them to your customer.
Clark, I have a quick question.
Sure.
On F, lead-based paint, it says lead-based paint disclosure. I know that recently I had a situation with the lead-based paint brochure where I had that initialed, but it was actually the lead-based paint disclosure. I think it's addendum D or P. Is that something that we need to go ahead and have the seller sign, the lead-based paint disclosure addendum?
So the lead-based paint disclosure when you're taking a listing should be executed at the time of listing and included on documents. It's part of our listing package for any property built before 1978. So the lead-based paint disclosure should be initialed on behalf of the seller because the buyer can't execute it until the seller's executed the lead-based paint disclosure. So it should be a part of your listing package or your listing presentation and listing documents. And then it's best to have it facilitate things by having it included in the documents in MLS. So you should have it initialed and signed, yes, the disclosure.
And the brochure, the lead, because there's two different ones. And I guess when we set up our listing package in app files, when you select the package, it does pull over both. But if you go in individually, you have to make sure you have the brochure and the addendum, the addenda, lead-based paint disclosure.
Correct.
Okay, thank you.
Right. You're right. You don't have any place to sign on the brochure, just like you don't have any place to sign on the energy brochure unless you add initials or dates to it. Kay was saying the permit's not closed will be found in a municipal lien search. Had one from 2011 that passed through 3 sales before being found with ours. Turned out easy to remedy, but caused a lot of angst for a couple of days. Absolutely, anything like that that pops up is going to cause some challenges. I'm glad it was found in the municipal lien search. Apparently it wasn't, for some reason it wasn't in the previous 3, which is concerning, but but I'm glad that you were working with someone who was able to find it. You were able to get that resolved, especially for your customer or for the customer, the buyer customer. Okay, right. Homeowners Association community disclosure: buyer should not execute this contract until the buyer has received and read the Homeowners Association community disclosure, if applicable. Why is this written in here? Does anyone have an idea?
Because that is going to affect the loan amount, or I mean the payments, and maybe the buyer cannot get the loan approval.
So you're exactly right that the information on the Homeowners Association disclosure will disclose the amount that needs to be paid to the Homeowners Association and the frequency, which can impact a buyer's ability to repay or a buyer's ability to get a loan, or impact the amount that a buyer can get in their loan. However, the real reason this is in here is because in the Homeowners Association disclosure, it says that if the buyer is not provided a copy of the documents related to the Homeowners Association, the covenants and restrictions, they can then back out within 3 days of receiving them. So this is a contingency that if the documents aren't provided to the buyer, or from the day that the documents are provided to the buyer, they have 3 days to back out. So you could be 15 days into this, 20 days into this, and the buyer's going, I don't have the covenants and restrictions. I don't have the covenants and restrictions. They're aware of the homeowners association disclosure. They're aware that covenants and restrictions exist, but they haven't been provided them. And now they're provided them. And you're 5 days before closing. They say, well, we were provided them 3 days ago and we're not willing to move forward because of this caveat within the association rules and guidelines, or rules, restrictions, and covenants and restrictions. Excuse me. So not only do they need to see a copy of the homeowners association disclosure, because the homeowners association disclosure gives them the right to review the covenants and restrictions, they have 3 days to back out from the time they receive those covenants and restrictions. So you want to get them to them, you want to get the most updated version to them as soon as possible after going under contract, or make sure that the most recent versions are available to them via documents. They should be made private so that the documents have to go through the agent, and then you can send an email to the agent saying, you know, hey, don't forget the documents are here, or provide them to the agent via email after going under contract. Cover
Yeah.
your Fanny as best you can. Go ahead.
Clark, I have a question because sometimes in the MLS I see that some properties say everything, the buyer needs to check all the information. So we need to research all this information. We need to call the homeowners association. We need to pull all that information. Or now the seller, the agent is, that is one obligation that they need to put that information for the buyer. Because before you can see in the MLS that we have to pull all that information if we want that property.
Well, we may be talking about a couple of different things. So what MLS is referring to when they say deemed reliable but not guaranteed, that means the information is deemed reliable. If they put notifications into either public remarks or private remarks that it's the obligation of the buyer, most often they're referring to, as in here, to confirm square footage and those kinds of things. It is the obligation of the buyer's associate and the buyer to ensure they have the documents before signing off on any addenda. So if an addenda is provided, like a homeowners association addendum, and the documents haven't been provided, there is an obligation from the seller through the listing associate to ensure they're providing the most recent documents to the buyer. Now, if you're not getting a response from either the listing agent or the seller through the listing agent, and you're not getting the documents, then yes, you have to pick up the ball and either contact the association to ensure that you have a copy. But remember, the buyer then has 3 days from the time they receive those, doesn't matter who they receive them from, to back out. Or they could back out because they haven't received the covenants and restrictions on the association or the condo.
The buyer has the 3 days after to receive this document, right?
After they receive and acknowledge that they've received the covenants and restrictions or condo association restrictions, they have 3 days to review them and then back out once they've received them. But after that 3rd day, they can't back out because of the covenants and restrictions.
Okay, thank you.
Val was saying that I was told by a buyer that a buyer can walk away up until the day of closing if the buyer did not receive the covenants and restrictions prior to entering into the executed contract. Is this true? The buyer can walk away up until the day of closing if they haven't received the covenants and restrictions. However, the executed contract should have included the HOA addendum. If the buyer initialed the HOA addendum and initialed the paragraph that said they had received the documents, yet they hadn't, then I don't understand how they would be able to walk away. But if they received the HOA addendum and have not executed the HOA addendum to indicate they've received the covenants and restrictions, then yes, up until the day of closing, they could walk away if they have not received a copy of the covenants and restrictions. They have 3 days from the date that they receive the covenants and restrictions to walk away. But in your example, yes, a buyer, if they have not received the covenants and restrictions prior to closing, on the day of closing, could walk away because they have not received covenants and restriction. But then my question becomes, what was the buyer's associate doing, knowing that those documents were integral in ensuring that the buyer was able to move forward? Did we do everything we could to facilitate the process as transaction brokers? Val was saying they're not easy to find. You used to be able to go onto coj.net. You're correct, they're not. So which means this is why the name of the association or contact of the association is now in MLS, so that everyone has a contact that they can go to. There's also often a charge to get the most recent updated version of the condo docs or the covenants and restrictions for a homeowners association. So there is that expense too. It should be the seller that provides those. So those are discussions you have to have with the seller at the time of listing, and then discussions you have to have with the buyer if you're not receiving them. How do they want to move forward? Anything else? Some agents don't know who the association is. As a listing agent, it's the responsibility of the listing agent to know who that is. So we have a responsibility to ensure that we're aware, because if we're not getting what we need from the seller in order to ensure that we can kind of move the process forward, we should be assisting in that process. So I think it's a matter of responsibility. If they don't know who it is, then if we're working with the buyer, we probably have to take on some responsibility or confront the buyer and say, how do you want to move forward with this? We don't have the documents. You don't have the documents. You have the right to get out because you don't have the documents. Do you want to see the documents? Please don't pull them from other listings. Please don't pull them from other listings. You don't know when those were pulled. You want to make sure that you get the most up to date. I get it. We're not working with, sometimes we're not working with others on, with agents on the other side that are as professional as y'all's, but remember, we're working as transaction brokers for the transaction, so we have a vested interest in ensuring that all parties get the information. All right, property inspections. So the one thing I did want to mention here is there's still a little confusion. The NEFAR document had time spots broken out. In the as-is contract and the standard, there's a certain number of days for an inspection period. In this inspection period, which has a default number of days of 15, so we'll use the default number of days when discussing this paragraph, that's to get everything done. A buyer can have as many inspections as they would like, gather as much information as they would like, and back out within that inspection period if they would like. If they don't like something that they see, this is their opportunity to really kind of check out the property and see what's going on. But it's a total of 15 days. There's no time period written into this that says, well, you have 15 days to do this and 5 days to do that and 3 days to do this, or 10 days to do this and 7 days to do that and 3 days to do this. It's 15 days. The buyer has 15 days to look at it, evaluate it, and say, I want in or I want out, or to say, I want in, but only if the seller is willing to do X or if the seller is willing to do Y. Other than that, if that doesn't happen within the 15 days, the buyer is accepting the property as is. The buyer is also responsible for the payment of all inspections, repair of any damage, restoration of the property resulting from the inspections, and shall provide the seller with paid receipts for all work done on the property. The preceding provision shall survive termination of this contract. So the buyer has a responsibility, whether they decide to move forward or not on a property, once under contract and have inspections, to provide copies of those paid receipts back to the seller to ensure that the seller does not get hit with a contractor lien because someone didn't pay for an inspection. But it's 15 days total, guys. 15 days is the default number of days. If you change that to 10 days or 7 days or 2 days or 12 days or 20 days, whatever you change it to, that's the inspection period. Everything has to be done within the inspection period. Any negotiation for repairs, any agreements. Go ahead.
Claire, That 15 days, for example, if the seller is going to fix something in the house because the buyer asked for that, but the repairs take more than 15 days, like, I don't know, 20 days, or we still in this period, so we can have more time to fix the things that needs to be fixed.
So the inspection period is for any inspections to be completed. If a buyer requests repairs, for a buyer and seller to agree to those repairs, it does not indicate, because this is an as-is contract, there is no indication as to when those repairs would have to be done. So even if the buyer and the seller agreed on, they have a 15-day inspection period, but the buyer and seller agree in 10 days that the seller is going to make some repairs, the seller doesn't have to have those done by the 15th day. They just have to have those done prior to closing.
Oh,
So there's nothing to commit. Excuse me? What were you saying, Yasmin?
oh no, that I understand that. Yes, I agree.
Okay.
Thank you.
Okay. So again, because it's an as-is contract, the buyer, there's nothing in here that says that the seller has to have the repairs completed in a certain number of days. So the buyer and seller would have to agree to that if there was a concern that the items would not be completed prior to closing. For example, a roof, how we manage it if it can't be done prior to closing. But remember, please, it's 15 days total for any inspections, any concerns, everything to be addressed, and any negotiation of those concerns to be taken care of. It does not include the actual repairing of those items. Anything else you guys want to add? All right. Walkthrough, something a little different here. On the day prior to closing date, or on a closing date prior to the time, on a closing date prior to the time of closing, as specified by the buyer or the buyer's representative may perform a walkthrough and follow-up walkthrough if necessary. And notice it says on the day prior to closing, or on a closing date prior to time of closing, as specified the buyer, they can have this walkthrough and subsequent walkthrough if necessary. So this is the same within 24 hours the day before. If you're going to have a walkthrough prior to, again, how do we manage that? We do it in writing and we negotiate it. Seller assistance and cooperation to close out building permits. So we're coming back to the building permits. If the buyer's inspection of the property identifies open or needed building permits, then the seller shall promptly deliver to the buyer all plans, written documentation, or other information in seller's possession, knowledge, or control relating to improvements to the property, which are the subject of such open or needed permits. So they still have an obligation to assist in the closing out of those permits. And as Kay mentioned, hopefully if the seller was unaware, or if it's gone a couple of transactions and not been found, hopefully the municipal lien will go ahead and find those, any of those open permits for you. But again, this contract, this document, contract for sale and purchase, does a really good job of addressing permits. We didn't do a good job of that with the NEFAR one, but the seller needs to be put on notice. Hey, are there any things that you've done to the property that needed permits or that you've got permitted? We need to make sure that those are closed out. So it reminds us of discussions we have to have at the time of listing. Assignment of repair and treatment contracts and warranties. At the buyer's option and cost, seller will, at closing, assign all assignable repair, treatment, and maintenance contracts and warranties to the buyer. So if there are certain things that are warranted, the seller has an obligation to provide those over to the buyer. If there's a cost to transfer those, it doesn't talk about those costs. Those would be the cost of the buyer unless negotiated. If there are repairs that the buyer and seller agree to, even on an as-is contract, the seller is responsible for providing those receipts, proof of payment, and those receipts over to the buyer, and any warranties that go to them, go along with the repair, over to the buyer. So anything that was done would need to be provided back over. So something just to remind our sellers of through the house they do once they go under contract. Slightly different. Don't see any hands up. Don't see any comments. Anybody want anything to add anything? Okay, so escrow agent. So these are the people holding the money. Any closing agent or escrow agent receiving the deposit, other funds or other items is authorized and agrees by acceptance of them. So remember, anybody who's holding the funds to deposit them promptly, hold same in escrow within the state of Florida, subject to collection, disperse them in accordance with the terms and conditions of this contract. Failure of funds to become collected shall not excuse the buyer's performance. Again, if they're not depositing the money as per the contract, they're technically in default. When conflicting demands for the deposit are received, or agent has a good faith doubt as to the entitlement to the deposit, the agent may take such actions permitted by this paragraph 13 as agent deems advisable. What we're going to see in paragraph 13 is that we have 10 days to try and help the buyer and seller. If there's conflicting demands over the deposit, then we have 10 days to, as the agent or agents in the transaction, to assist in the negotiation of that binder as to where it's going to go or how it's going to be managed. Sorry, it came back with mute on. So you didn't hear any of that. Anyway, so the escrow agents or the agents holding the monies will commonly facilitate the process if there's a dispute over escrowed funds. Most title companies or attorneys have an established guideline. Usually the first 10 days are the most important. The agents often facilitate the process between the two parties. However, it would not be uncommon to bring the title company or escrow company into the negotiations early on to help facilitate the process between the parties. What they will often do is say we have 30 days, 60 days, 90 days for the two parties to agree to how the monies will be distributed, or we're going to go ahead and turn it over to the clerk, to the circuit court, and to the clerk of the circuit court, and have the state hold the monies, and then the individuals are going to have to petition for the funds. So if it's not a brokerage holding the monies, remember, if a brokerage is holding the monies, it goes to the Department of Business and Professional Regulations, the Florida Real Estate Commission, and it's mediation, arbitration, escrow disbursement, litigation, or interpleader. MEAL. Mediation, escrow disbursement, arbitration, litigation, or interpleader. Okay, there we go. All of them. but that's held with the brokerage. Not held with the brokerage, held with the title company or an attorney. We have to go by the guidelines of those two parties. However, we do play a role in the potential negotiation of that binder, especially for the first 10 days. This is a little different. None of this was in the NEFAR contract. It really focused on money being held by a brokerage. So that if there are conflicting demands over a binder, you have an obligation. Anybody want to add to that? All right. Under professional advice, something to be reminded of, the buyer agrees to rely solely on the seller, professional inspectors, and governmental agencies for verification of property condition, square footage, and facts that materially affect the property value, and not on the representations, oral, written, or otherwise, of the broker. So remember, your buyers are going to have a lot of confidence in what you do. Asking the right questions is, I think, a huge role that we play. Just as when we list the property, when we're working with the sellers, we need to make sure that they are aware that the buyer is going to depend on the seller's information to be able to verify that information in that purchase. So if they're thinking they're buying 5,000 square feet and they're buying 3,000 square feet, that impacts not only what the buyer believes the value is of the property, but it also provides an opportunity for the seller to clarify what their where they believe the square footage is on the property. So it's something that comes up a lot. Who is responsible for the square footage? Well, the buyer is responsible for ensuring that they get the right information. So is it a tax record information? Was it measured? Did they have a professional inspector that measured the property? Any other terms and conditions that would be considered affecting the value of the property would be items that the buyer would be responsible for confirming. However, they would be dependent upon the seller. And professional inspectors, and guess what? You're a professional, so they expect that you'll have the right information too. Anything else? Okay there? Looking. Let me bring chat back up. Yes, I saw that. Thank you. Kay is saying 10 days. What does it say? 10 days for the negotiation. So back up here, we have the 10 days is, where did I read that? Payments, liabilities. Oh, shoot. Where is that now? Oh, maybe not. Thanks for pointing that out. I thought there was 10 days in here. Disclosed part of 13. Choice not be allowed with the parties. All right, so you have as long as it takes, I guess. Sorry, don't know where I read that then. I'll have to look that up. So you're not limited to 10 days. I was sure that was. I'll have to look at that up and get back to y'all, see if that's impacting. I read 10 days on something related to disputes over the binder, but this, without the 10 days in here, gives you, it pushes us back to the individual holding the title company holding the monies. So we should be good there. You're not restricted to 10 days, but you do have an obligation to go ahead for this contract to work with the buyer and seller in negotiation. Thank you for finding that, Kay. All right. Dispute resolution. Oh, sorry. Buyer and seller should have 10 days after the date of conflicting demands. Found it. Conflicting demands for the deposit to be made in an attempt to resolve the dispute, failing which the buyer and the seller shall submit such dispute to mediation under paragraph 16. So it's not the dispute, it's not the 10 days up here as it relates to the dispute over the monies. It's down here. The process, the way that the dispute resolution will be resolved is you've got 10 days and then goes to mediation if they choose to go to mediation, or if it's escrowed monies, then it goes to the process that the title company or the escrow company holding the monies has set up. Again, usually 30, 60, or 90 days, and then turn it over to the turn it over to the state. No, thank you for the clarification. I was getting my paragraphs mixed up. We're into the standards for the real estate transactions. These standards are pretty much disclosures, so title disclosure, restrictions, easements, limitations. The disclosures here, or the standards here, take what was outlined in the NEFAR contract and go into much greater detail. The title examination section was related to the closing date in the NEFAR purchase and sale agreement. Here in this contract for sale and purchase, the title examination is much more detailed, as is the survey section. It does go into ingress and egress and lease information. These are all standards. They are identified as standards. These are fairly consistent from transaction to transaction. Liens, time is of the essence. That was a separate paragraph. It is very similar. It does indicate calendar days for time is of the essence. So it's calendar days, except when a time period ends on a Saturday, Sunday, or national legal public holiday, right? So if it ends on any of those days, then it moves to the next non-Saturday, Sunday, or national legal holiday. Force majeure, war. So watch your deadlines here. Happens if there's disagreement, or if there's something that puts us into a difficult situation. Conveyance, the seller shall convey the marketable title. So what happens if they don't have that? There's notification. All party of the sellers were required to notify the buyer. And of course, closing attorney has to resolve that. If it goes longer than a specific period of time, then the buyer can back out. Seller has a responsibility to resolve that. Closing location documents, location redacted by an attorney or closing agent. So that's defined here, designated by the party paying for the owner's title policy. So it's specific to that, which goes back to that one paragraph related to who's paying for it, buyer or the seller. Closing documents, nothing really different there. Reporting obligation for the FinCEN. So if it is a company or organization, LLC, S corporation, C corporation, even PA, have to report. Any procedure, these shall be recorded upon collection of all closing funds. So it's just much more detailed. Escrow closing procedure, how the commitment is issued, prorations and credits, a lot more detail provided on all these standards, which were paragraph 13 in the NEFAR contract. You would just line them out individually. So access to property to conduct appraisals, inspections, and walkthroughs. The seller shall, upon reasonable notice, provide utility services and access. This was also in the NEFAR contract. So remember, when we're listing a property, they have to make sure that you're talking to your seller about any items that, or making sure that the utilities are on so that they can be tested during any inspections. Risk of loss, exchanges. This puts it in bold that the contract is not recordable. So this contract is not recordable. It's the note mortgage that are recorded. And the title obviously. And are confirming that they understand. So if they want to seek an attorney to go into this further with them, then please make sure that they have that opportunity in writing. Waiver, failure, buyer and seller to insist on compliance or strict performance, any provision of this contract or to take advantage of any right constitute a waiver. So if buyer hasn't made a deposit and we don't call them out on that deposit, but then they make the deposit, and the seller moves forward with the contract, then what they're doing is saying that even though they didn't make it in a timely manner, it's okay that they made it and the contract moved forward. So if there's a problem, we need to make sure that we're talking to the sellers about it and notifying the buyer on the other side. Yasmin just said that there's a problem with the sound again. Can someone verbally say yes or no? So I know.
It was.
It was. Is it clearer now? Kay said yes, there is a problem, or yes, it's clear now. I wasn't sure which.
It is clear now.
Okay, all right, thank you. Any additional riders? All right, any additional riders, addenda typewritten, so they supersede what's in here, but all are required in order to have a fully executed contract. Collection or collected means any checks tendered, so when were they clear? If a check is given and it bounces, that doesn't mean that it was given in a timely manner. The funds have to be available. So you would have to extend the time for that check or that binder to be delivered, or amend the contract for that binder to be delivered if it bounced. All parties would have to agree. Notice of responsibility for the IRS, yay. W is reserved. I'm sure we'll be adding something to that. Then we come down to the addenda. Notice we've now added FF and GG to the addenda. Anything that's selected here has to be included and executed for you to have a fully executed contract. So if GG, this is happening a little bit lately, if GG is selected and GG is not included, I'll be asking you for an executed GG addenda. Just like if you had a short sale addendum and I didn't have it, I would be asking you for that. So anything that's selected has to be included to have a fully executed contract. The flood disclosure would need to be put here under other because it has not been added yet. Are there any additional terms and conditions? So where things are written in. Okay, so let's talk about this for a second. Any additional terms, if I write in here that the buyer requests and seller agrees to pay buyer brokerage 2% to, let's do 3%, 3% of purchase price. Okay, this is now a request from a buyer to a seller, and this is 3% brokerage compensation. So pay buyer broker 3% of purchase price as buyer brokerage compensation. If this is in here and it's between the buyer and the seller, I do not have to have a compensation agreement. So if you write into the contract that the buyer is requesting 3% towards the buyer's brokerage agreement, or that the seller pay 3% of the purchase price as, you know, satisfaction for a buyer's broker agreement, as long as it's a buyer requesting, a seller requesting, and it's in the contract and the buyer and the seller agreeing to it, you don't have to have a compensation agreement. So this is a little bit new. We've been asking for compensation agreements on all of your transactions, but what we've been advised by attorneys is that if it's in the contract and it's coming from the buyer to the seller and all parties sign off on it, the seller is agreeing to pay a certain percent of the purchase price to a buyer's brokerage, you're fine. You don't have to then have the compensation agreement. So this is a little different than what we've been asking for you to do. But it's what we're all in change and learning. So this is a way to avoid the compensation agreement. That's why we removed the compensation agreement as a required document from our checklists, because it'll depend on what's written into the additional terms and conditions.
Clark,
Yes.
before we can, or the seller can negotiate this 3%, right? Because we used to say, oh yes, my seller is agreed to pay right now, but it can change through the negotiation, right? But if it's here in the additional terms, seller has to pay the 3%, or he can change their mind too.
So if I'm working with the buyer and I write this statement into paragraph 20 and the seller does not want to pay 3%, then it would be a counteroffer. You would counter this amount.
Yes, but if it's the seller and buyer sign this offer like this with the 3%, and then the seller change his mind and say, no, I'm not going to pay 3, I'm going to pay 2. Do we need to
Okay.
change these additional terms, or?
So if a buyer and seller, so if I've written this into my offer and the buyer sign off on seller the contract is opened up for negotiation. So for example, you had a case where the buyer was asking for repairs. Can you hear me now? I can see, so if you can hear me, Dee, can you shake your head? Or no?
It's cutting in and out. I can't hear you.
All right. Is it clearer now?
Yes,
Still cutting in and out?
I hear you.
Okay. All right. So, yes, clearer. Okay. So Yasmin is asking if the buyer and seller agree to this 3%, can the seller change their mind? Yes, the seller can change their mind to pay 3% to the buyer's broker. They can change it only if the contract is opened up for renegotiation in some way. So for example, if the buyer and the seller agree to the 3%, and have a fully executed contract, the seller is committed to paying 3%. Now the buyer comes in and says, I want all these repairs done or I'm walking away. And the seller says, well, I'll do those repairs, but I'm not paying 3% and doing those repairs, because the buyer is asking to open up the contract for negotiations, because you're talking about an as-is contract where the buyer is accepting the property as is. And now they're asking for the seller to spend money on expenses or spend money on repairs. And the seller can say, well, I'll do those repairs, but I'm not paying the 3%. So the only way for the amount to change once it's agreed to, once you have an executed contract, is when the contract gets opened up for renegotiation based on the fact that a buyer or a seller would like to change something in the executed contract. It would be the same if you had a compensation agreement that was executed at 3%, and now the contract gets opened up and the seller decides they're not going to pay 3%, they're going to pay 2.5% and make the repairs. But once it's executed, it's a contract. All terms and conditions need to be abided by unless the contract is opened up for renegotiation in some way. That can include any term or condition changing. Closing date, loan approval, type of loan, time for time to make application, number of days for inspections, any of those things. Open up a contract for renegotiation.
I have a question,
Does that
Clark.
answer your
If you have a
Yeah.
buyer broker agreement before you have the contract and the buyer says they're gonna pay you 3%, and then you add this additional term, and then the seller changes and said, no, I'm only gonna pay 2% because you want me to do these repairs. Does the buyer put the other 1% that they agreed in the compensation agreement at closing so that I still end up with 3%? Or does it get overridden? The buyer broker agreement gets overridden because we put 3% in here and then this changed to 2%, that was all that the seller was agreeing to pay.
No, the way that the buyer broker agreement is established is that any monies that come from the seller are credited to what the buyer agrees to pay. So the contract between the buyer and the brokerage is the contract between the buyer and the brokerage. If it's at 3%, the buyer has committed to pay 3% at closing to us. If the seller is willing to pay something towards the buyer's broker, for example, in your example, you said 2% that the seller was paying, then
Right.
the buyer would get credited 2% and only have to pay 1%.
Okay. Okay.
Which leads to the question, can you modify the buyer broker agreement? Yes, you can modify the buyer broker agreement. It would become a negotiation. The buyer could potentially say, well, the seller's only paying 2%. I need to renegotiate with you what I've agreed to pay you.
Okay.
In other words, it's better that that the buyer pay us, that the seller pay us, because we can get less compensation if we have to renegotiate the contract.
Well, I mean, we've set standards for what we believe is appropriate on a buyer broker agreement. So if you go off of that, then you would just be paying the company dollar differential. But yes, if you go in and sit with a buyer and prior to working with them or showing them properties, and you and the buyer agree that the buyer will pay you 3%, remember, you can't get any more than that unless that buyer broker agreement is modified. So if you agree to 3%, and then through negotiation, the seller agrees to pay 2% to the buyer broker, then the buyer knows at that point that they're obligated to 1%. If you modify the buyer broker agreement to 2.5%, then the buyer knows that they're responsible for 0.5%. If you have a buyer broker agreement at 3% and the seller is willing to pay 3.5%, you would have to modify the buyer broker agreement to be 3.5%. Otherwise, you could not collect that additional 0.5%.
Okay.
Yeah.
I think I got all that in there. So remember, the whole thing now is the buyer negotiates with the buyer's broker, the seller negotiates with the listing broker, and anything that the buyer and the seller agree to are the terms and conditions of the contract. If within those terms and conditions there are concessions, then those concessions can be divvied up in whatever manner the buyer and the seller agree to, as long as all parties are aware. That's why this verbiage is important, that the buyer requests and the seller agrees to pay the buyer brokerage a certain amount, because then the seller knows what this amount is going to, or who is getting paid this amount. If the seller agrees to pay $50,000 and the buyer wants to use some of that money towards the buyer broker agreement and some towards rate buy down or anything else, then the best place for that to occur is in FF. We'll get to FF in a minute, the frickin' form. And I know we're at 12:08. I understand if somebody has to drop off. We're running a little long, but if you're able to stay, I am going to go ahead and go through those additional documents. We got those additional terms and conditions here. It's intended to be legally binding on the contract. Attention to the seller and buyer. Here's your notifications. There really isn't much of a wire fraud in here. just noticed that. Is it someplace else that I missed? Anybody seen it in here? Oh, there it is. Buyer waiver. No, it's not waiver. Not wire fraud. Kelly, we need to look at making sure our customers are aware of wire fraud. We did have an issue with a very large sum of money just before the end of the year on a transaction, some money that got wired to the wrong location. So fortunately, they were able to get it back, but hadn't realized that. Okay, so we probably need to make sure that our customers are aware of wire fraud or add that wire fraud disclosure. Dang it. Okay. All right. Anything else that you guys are experiencing in the contract for sale and purchase that you want to make sure that gets addressed, asked, or worked with? One thing I just thought of here, if I were to say that the seller to provide 30,000 in conditions, this is probably not the best place to put that. Because it doesn't disclose how that $30,000 is being used. And that was one of the things that came up a lot, was making sure that there's transparency. So this would not be appropriate for here. Delete that.
So Clark, if that's not appropriate,
Yeah.
how would that information be disclosed in paragraph 20 if there were 30,000 in concessions?
So if those $30,000 were just for like rate buy down, closing costs, you could say that and be more explicit. Otherwise, really FF is the best way to use that. So it's a good transition to FF. Is under FF, what we see is that if initialed by all parties, the clauses below will be incorporated into the Florida Realtors FAR contract for sale and purchase between the seller and the buyer for this property, and both parties initial. What this does is it says that the buyer has entered into a separate brokerage agreement as may be amended, which is called a buyer broker agreement. Remember, that is the showing agreement, the exclusive buyer broker agreement, which is not incorporated herein. So the buyer broker agreement should not go to the other brokerage. It is not uncommon for the title company to ask for it so they know the buyer's liability. It's not uncommon for the lender to ask for it so they know the buyer's liability, but it should not go to the other brokerage. There is no obligation to give it to the other brokerage. It is not something they should have. This is in conflict with what builders are doing in asking for the buyer brokerage agreement, because they're attempting to max out the compensation that they will give rather than establish what they would like to offer. They should just be willing to offer it. I'm sure many of you are seeing that most agents are not calling now asking. They're just providing either a request for compensation through the buyer or the buyer's request for compensation to the buyer's brokerage comes either in the form of a statement in paragraph 20 or as part of a compensation agreement. At closing, the seller agrees to credit the buyer the sum or sums described below, which for disclosure purposes only the parties agree is related to the buyer's obligation under the buyer broker agreement to pay all or a portion of the buyer's broker compensation. So if it was $30,000, I would use this option and put $30,000 here. And that allows the buyer to use some of the money towards their buyer broker agreement, all of the money towards the buyer broker agreement, or some of it towards their buyer broker agreement, and some of it towards other closing costs. If it's just an amount, for example, 3% of the purchase price, and that's all we're asking for, we're not asking for anything else. Buyers just asking for assistance with their buyer broker agreement. You could put 3% in here or whatever amount that they've negotiated with us. And then that amount can be used towards the buyer broker agreement, and all parties are put on notice. If the buyer is requesting a certain percentage, which is equal to or similar to what they've agreed to in their buyer broker agreement, plus an amount to be used for concessions like closing costs, down payment, rate buy down, then you could put a percentage plus an amount of money. If by chance this percentage exceeds what's allowable by a lender, or if this amount exceeds what is allowed by a lender, or these two combined exceed what's allowable by a lender, then to the extent it's permitted by the lender, then the balance of the credit will be paid to the seller directly by the buyer broker, or the credit will be reduced to the maximum amount allowed by the buyer's lender. So not only the buyer, some of the monies may be used towards a buyer broker agreement, and it lets the seller know that if they've agreed to an amount, the seller can choose whether the difference, if it's precluded, if the amount is precluded, or if the amount is restricted by the lender, that the monies will either be reduced to what's allowed, or that the balance will be given directly to the seller. We'll go back to the seller. Directly, excuse me, to the buyer broker, directly to the buyer broker. Then the onset of your negotiation, at the onset of your relationship, you cannot collect more than that. Okay. This rider shall not modify the buyer broker agreement. Let's see. Okay, so now all right, I don't know. The only person I can see is D. So can you hear me, D? If you want to shake your head yes or
No.
no, or
Now I can hear you. Now I can hear you. I couldn't hear what you were saying before about the overriding the buyer broker agreement. I didn't hear that.
okay. All right, so this document does not override your buyer broker agreement or modify it. You would have to do that in a separate agreement, because this agreement is between the buyer and the seller. The buyer broker agreement is between the buyer and the buyer's brokerage.
Okay.
Did everyone get that?
Yes. Yes, got it.
Did anyone? Okay, I'm sorry, we're having trouble with the sound. Let's hop over to GG for a minute. All GG does is create a contingency. This places a contingency on the contract Well, there are a few of you here, so there you go. Thanks for being patient. I don't know what is going on today. Can you all hear me now? Anybody?
Yes, we can hear you.
Okay. So we were talking about Gigi. I'm gonna talk fast so that this is the last time you have to do this. This just places a contingency on the contract that a compensation agreement will be executed. And there's a certain number of days in which that a buyer, or excuse me, an agent, a buyer's brokerage has to execute one in order to ensure that they're getting compensated or know what they're getting compensated. The buyer needs to know that, because if they've signed a buyer brokerage agreement that's different from what the seller is willing to pay the buyer's broker, then the buyer needs to know and the lender needs to know, so that they are able to confirm whether or not they can purchase a property at that price. So this just places a contingency. It does not take the place of a compensation agreement, nor does it add a reference to the compensation agreement into the contract as being a formalized document. It just says one will be executed. It's agreement between the buyer and seller to execute one, or that one will be executed outside of their agreement. But it does place the contingency on it. The flood disclosure, the only thing I did want to mention about the flood disclosure, please have your sellers, when you're taking a listing, complete this, but do not fill in this box. I know we're all used to this being the box that says when we've given it back to the party that signed. This box is for the buyer. This box says when we gave this document to the buyer. Can you put this document in additional forms or additional documents on MLS? Yes, you can. But please do not fill this out down here. Otherwise, you'll have to just cross out the date and then put the date that the buyer actually received it on there. So this, when you're taking a listing, the only thing you have to worry about is, did the seller fill it out? Did the seller sign it? Not when it was given to the buyer, because you don't know that until you have a buyer. All right. So thank you guys for your patience. Is there anything anybody wants to add, ask, or put out there while we still have a connection? Did everybody go away? Oh, maybe they put it in the chat. Oops. Val says she's good. Thanks you guys for hanging out a little bit longer. Again, I apologize for all the sound issues and the cutting out, the dropping off. I'll see if I can figure out what that is. I'll restart the system here. But that's not something I should have had to do, so I apologize. Anything anybody wants to add before we close up here? Okay, for what it's worth, I'll try and put this out on YouTube. Maybe you can fast forward through some of the pieces. All right, thank you very much. I'm going to go ahead and stop the recording. And